Good afternoon or good morning, depending on where you are in the country at the moment. I'm Bob Haig. I'm the chair of the Commercial Division Advisory Council in New York, and I'm also a litigation partner at Kelly Dry and Warren. The Advisory Council, which is presenting this program, is a group of judges, in-house counsel, and litigators at law firms appointed by New York's chief judge to advise him or her, as the case may be, on all matters involving or surrounding the commercial division of the New York State Supreme Court, as well as to keep him or her advised of developments in the business world and community that may affect the court system. And incidentally, for many of you outside of New York State, the commercial division is part of the New York State Supreme Court, which is the highest trial level court in New York State. Our highest appellate court is the Court of Appeals. And the clerkships we're going to be talking about today are trial level clerkships, not appellate level clerkships. We're going to jump right into the program in just a minute. Just a quick review for those of you who have come in from different angles. There are two principal purposes of this program today. The first one of those is to discuss with you positions that are available, not just now, but in the future and on a regular basis for law clerks and law interns in the commercial division of the state Supreme Court. We think that these clerkship opportunities are extremely attractive for the reasons that we're going to discuss with you during the program. We would be grateful if you would inform your students about, and as well as your graduates, when you communicate with them about these opportunities. We think that the clerkships will not only enhance the education and the professional development of your students, but we think it will equip them to find employment with a law firm that will appreciate and value their enhanced knowledge and skills. The second main purpose of the program is to tell you, as you'll hear in part of the program, about the commercial division's history and current capabilities. In other words, to put these clerkships in context. And you should know in very broad terms that there is a national and international trend toward development and creation of business courts. And that has arguably transformed the business litigation landscape in many jurisdictions throughout the world. And the commercial division is one of those business courts. It has served as a model for many of the other business courts. And to let you know the scope of this, there are now 28 states that have got business courts. There are more than 35 countries around the world that have got business courts. They're receiving increasing attention in academia. There are law review articles being written about them. And we think it's of interest for that purpose as well. So we've got a jam-packed agenda, which we're going to jump into and finish by 2 o'clock. We're going to save questions for the end. The members of the audience can use the Q&A feature on Zoom if you've got a question. What you need to do is to type out your question, and we'll deal with as many of them as we can at the end of the program. You're also free to send an email to me after the program or to my assistant, Grace Grissett, that you've gotten a number of emails from in the past. And we will try and respond to you as promptly and thoroughly as we can. So without further ado, I want to jump right in. And the first speaker on our agenda is Kathleen Sullivan. And I am not going to give introductions other than the name and affiliation of the various speakers. We don't have time for that. What you probably need to know is that Kathleen is the Sullivan in the well-known and well-respected 1,000-lawyer business litigation law firm known as Quinn Emanuel Urquhart and Sullivan, and she's the founding co-chair of their national appellate practice. So, and Kathleen and I are going to have a conversation about this. And let me start out, if I may, asking us if you will tell our audience about your background in the academic community.
Yes, thank you, Bob. And it's such a privilege to speak with you today because you are, of all the members of the practicing bar, the most important visionary and architect behind the creation of New York's commercial division. And we're so grateful for your role in it. I was privileged to be a law professor for 28 years at Harvard and Stanford law schools, and also to serve as the dean of Stanford Law School. And for the last 2 decades, I've had the privilege of practicing commercial business litigation at the law firm of Quinn Emanuel Urquhart and Sullivan. So I've had the privilege as an appellate lawyer to see many cases coming up from the commercial division through the New York appellate courts. So I have seen the operation of the court, and I've also served on the Chief Judge Lippman's task force for the commercial litigation for the 21st century. And that was a task force that issued a report in 2012 that was extremely important to creating a number of procedures and innovations that streamlined and improved the already great work of the court.
Have you had any particular involvement with judicial clerkships?
Yes, I have, Bob. I was privileged to serve as a law clerk to the great Judge James Oakes on the United States Court of Appeals for the Second Circuit. And over my time as a law professor, I think it's fair to say I wrote hundreds and hundreds, if not thousands, of recommendation letters for my students to get clerkships on various courts. So I've sent a lot of students to a clerkship, and I can say to the audience here that I think for myself and for many of my students, having a clerkship at the outset of one's career is the finest professional preparation you can have for a career in litigation.
Let's talk about the commercial division for a minute. What is your view of the commercial division?
I think it's an absolutely splendid court. It's a gem in the New York court system. It's a place that, it used to be a common place before 1995 to think that business clients often preferred to go to federal court to resolve their disputes, or to resolve their disputes outside of court and not to want to go to state courts. The commercial division has transformed that reputation over the past 3 years. It's now the case that major corporations and clients are very content. Nobody wants to have a dispute, but if you have to have one, they're content to have it resolved by the superb judges of the commercial division. And to see the absolute work that's gone into making it an efficient court, a court with great expertise and wisdom, and a model for business courts in other jurisdictions.
And I mentioned a minute ago about this trend toward creation of it's a national and international trend toward creation of business courts. How does the commercial division fit into that trend?
The New York commercial division is the absolute model for every other jurisdiction that's taken this approach. It was the first to develop a commercial division back in 1995. The past 3 decades have seen the New York commercial division develop many procedures for alternative dispute resolution, the streamlining of discovery, the ability to generate quick opinions, which is enabled by the law clerks who come to work for the judges of the court. And its reputation is stellar. If you are recommending to a young law student who wants to be a business litigator, where should you begin your career? I would highly recommend that you send them to the commercial division. It is the lead, it is the beacon.
One thing maybe we should clear up for the audience is that I suspect many people in the audience have heard about the Delaware Chancery Court, and yet we're talking about the New York Commercial Division as the leader. But there, I think that the commercial division is the first business court of general jurisdiction, as opposed to the Chancery Court, which for much of its history has been a court of exclusively equitable jurisdiction. Any other thoughts on that or comments?
That's absolutely right, Bob. The Delaware Chancery Court is a great court. I've spent a lot of time there. My partners spend a lot of time there, as my partners spend a lot of time in the commercial division, but they're different courts because, as you say, notwithstanding the end of the split between law and equity, the Delaware Chancery Court is still a court of equity. If you can't figure out a way to characterize your case as equitable, you can't be in the Chancery Court. Whereas legal cases involving damages, often in staggering amounts of money, can be fully litigated in the New York Commercial Division. So they're different. New York Commercial Division is a more capacious and versatile place to resolve business disputes.
And what would you say specifically to law students that are considering whether or not they should pursue a judicial clerkship in the commercial division?
I would say run, don't walk. I mean, this is a phenomenal opportunity. If you want to practice business law, if you want to practice business litigation, there could be no more superb opportunity. And it's for three reasons, Bob. First, the judges. Working on the commercial division, you will work for the finest judges with the greatest intellect, the greatest energy and stamina to take on large records and large disputes, an ability to make decisions efficiently and ability to bring disputes to resolution. You will learn to model yourself on those superb judges, many of whom you'll hear from today. Second, the subject matter. If you want to practice business litigation, you're not going to learn everything you need to know, even if you have a wonderful clerkship in the federal courts, because the federal courts will involve criminal cases and administrative cases and immigration cases and many things that are at a far remove from commercial contract disputes, securities disputes, and the like. But if you go to a clerkship on the commercial division, you will learn about complex contract disputes. You'll learn about securitization of exotic financial instruments, and you'll learn a great deal about procedure. And I want to emphasize that, Bob, you could learn so much in a trial court, any trial court, including a federal trial court, about procedure.
Seem to be frozen, I think. Mike, is that Kathleen or is that
lawyers
us?
You'll see. You'll see practicing lawyers who are the finest practicing lawyers before the commercial division, and you'll model yourself on them as well. So those are the 3 points, Bob.
And last question for you. What would you say to law schools about encouraging students to pursue these clerkship opportunities?
I would urge law schools to be very proactive in encouraging students to pursue these opportunities, because law students tend to reflexively think they should go to the federal courts. And yet, for your practice, if you want to be a business litigator, you will learn so much more in the state courts. I mean, we're delighted whenever we have a law student apply to our firm, Quinn Emanuel, who has had a clerkship in the New York State courts. We're delighted to send our students to clerkships, our associates to clerkships on the commercial division or the New York Court of Appeals. These are wonderful opportunities, and they probably don't get as much press as federal clerkships do. And so I would encourage all the participants in the call to make an extra effort to encourage their students to seek out this wonderful, life-altering opportunity of a clerkship on the commercial division.
Thank you very much, Kathleen. We appreciate your participation.
Thank you, Bob.
I'd like to move on to the next segment of the program. And our next speaker is Tracy Davis, who is a partner at Seaforth Shaw. She's a former chair of the New York City Bar's Judiciary Committee, and she is a former principal law clerk to one of the commercial division judges. And Tracy, if I can start in with you with a question, if I may. And that is, it's now been 2 decades since your clerkship in the commercial division. And in what ways do you believe that that clerkship has enhanced your practice?
Thank you, Bob. I'm happy to be here. And I can say certainly the proof is in the 2 decades of private practice that I've experience thus far, and saying that it truly trains one to think like a judge. The judges in the commercial division get huge, massive numbers of motions annually. They run in the tens of thousands, and they vary in complexity, more often complex than not. Multiple parties are generally involved, where they each have varying interests and stakes when in the ultimate relief or in the relief sought on that application. And I can tell you, the ability to sift through thick, dense motion papers on complex issues trains one's mind to think in a highly compartmentalized way, to keep the rights and responsibilities of the parties in mind, such that you are able to parse through where the ultimate outcome should be reached in deciding a motion. I think Kathleen mentioned how the commercial division judges hone their skills and expertise on these exotic types of issues. As one who spent 6 years in the commercial division, I can tell you that that is certainly the added benefit that one who takes on a clerkship obtains by working with highly sophisticated judges who have highly sophisticated lawyers come before them with very well-written papers in deciding front page issues.
Tracy, you're the immediate past chair of the City Bar's Judiciary Committee, and you've seen a lot of judges, state judges, federal judges, commercial division, and others. What sets the commercial division judges apart?
So not only in the non-commercial parts within New York State, but around the country, I've litigated cases in those courts. And I can tell you, where it comes to a business dispute, the degree of expertise and level of sophistication that those disputes are going to be handled with is really unmatched. I mentioned the motions, I mentioned the complexity of issues. It's through having dealt with a wide array of business issues that the commercial division judges just have the kind of depth of expertise and experience to provide swift resolution of business disputes. And that's critically important because if nothing else I've learned in my 2 decades of private practice, that's what businesses need. That's what they want. They want expeditious resolution so that they can move on with their own business operation.
Tracy, you're a partner in a large law firm and you're involved in hiring associates. What attracts law firms to hire former clerks, particularly from the commercial division?
It's not simply just the depth of skill set that a newly admitted attorney will acquire, whether it's a legal analysis, research, writing, all of that, of course, will come spending time with commercial division judges. But what is unique is the relationships that are often acquired that most law firms can't get anywhere else. Knowing how the system operates, I recall my days knowing the right clerk to talk to oftentimes can get your case moving in the right direction. So I think it's the skill set, the relationships, and of course, then the ability to have those, the diversity of thought that's often needed in efficiently and quickly resolving or helping your client to resolve litigations or other out-of-court business disputes.
You've mentioned skill set a couple of times. And in your position, you need to market that skill set to in-house counsel. How has your experience in the commercial division helped you do that?
Well, it's helped me in that you clearly you have the bona fides to tell the client that in fact how the system operates, whether to their advantage or disadvantage, is going to help them with their dispute. They're looking for guidance. And obviously you can provide them with that guidance, but you can also instill a sense of trust, reliability, by knowing that by selling to your client, the fact that you do have that to back up what you're saying.
Thank you very much, Tracy. I'm going to move on to another segment, which is on practicing in the commercial division. And the two panelists on that topic are Roberta Kaplan, Robbie Kaplan from Kaplan, Hecker and Fink, and Kevin Schwartz from Wachtell, Lipton, Rosen and Katz. And I want to, in this segment, just touch on briefly a couple of the outstanding features of the commercial division and get your comment on it. Robbie, there've been some comments already about the judges in the commercial division. You know, in choosing the commercial division, what is it about the judges that would motivate you to go to the commercial division?
So I remember, I'm going to do a little bit of history here, keeping with something Kathleen said. I one of the probably the older people on this panel, and I actually had the great honor to clerk for Judge Kay the year after she set up the commercial division. And believe it or not, as I recall, it was actually controversial then that she was creating another specialized court within the New York court system. And there was honestly, as I recall, quite a bit of resistance to it at the time. Obviously what she did, and her memory is a blessing to me, but what she did back then was so foresighted and was so smart, and has been such a benefit to our state and our court system, and to lawyers like many of us on this call who litigate in the courts every day. There's always been debate in academics about whether specialized courts make sense or not. As people know, there's some specialized courts in the federal system, but there's not a lot. And civil procedure professors love to write articles debating the advisability of having specialized courts. In this context, it seems to me that there's really no question that the commercial division is a boon to lawyers, to litigants, and frankly, to the public. And the reason is, from the perspective of a lawyer, is that when you're advising a client who has a problem about what to do, whether to litigate, what position to take, whether to settle, etc., the most important factor, at least in my mind, is predictability. You want to be able to say to the client, you know, no one knows the future, no one can predict anything with certainty or near certainty, but you want to have a good sense of how you think the court and the judges will handle whatever the legal dispute is. And the commercial division, because of the quality of the judges on it, because of the experience of the judges on it, gives lawyers and litigants all of those advantages. And in certain respects, it's sometimes, honestly, let me put it this way, in cases when there is federal jurisdiction, so you have the option of going to the SDNY or the EDNY, depending upon the case, I often find, and will tell clients, that there are advantages to going to the commercial division in a commercial dispute, because you know that whatever judge you will get in the commercial division has handled hundreds of them, if not thousands of them, and will be incredibly knowledgeable about the law and the issues that come up, etc. While I'm a huge fan of our federal judiciary, obviously, there are many, many federal judges that don't have that same background. And frankly, because of arbitration agreements, etc., there are far fewer, I hear this a lot from the federal judges who complain about this, there are far fewer commercial cases in the federal court, so they don't have the same kind of experience. So for a lawyer representing a client who's trying to find a solution to whatever the problem is, in many, many circumstances, it's hard to come up with a better solution in the commercial division for all the reasons I said.
Kevin, what about professionalism, fairness, integrity? You know, these are pretty important concepts involving courts. What about the commercial division?
Again, for the exact
No,
same
that's for
reason.
Kevin.
Oh, I'm
That's for
sorry, Kevin. I apologize. So you have the floor.
I am quite confident I'd be comfortable resting on whatever Robbie says. So by all means, please add to whatever I miss. And thank you, Bob, for the question. Pretty important concepts indeed. And I will flag, you mentioned this about Tracy, I'll say it as well. I have the honor of working in the same position as my friend Tracy did as former chair of the Judiciary Committee. And those qualities are something that people spend a lot of time and a lot of hard work ensuring are true of all those who seek judicial posts within New York State, and absolutely critical to service on the commercial division. You know, having responsive judges who are prepared, who have the temperament to take on this position, who have the sophistication to lay bare well-reasoned analysis and a well-developed body of law, assuring the greater predictability of outcomes that is essential in a business court that can claim, you know, world-class status. All of that builds on the integrity, fairness, and professionalism qualities that you mentioned. And a lot of smart people and hardworking people put in a huge amount of time to make sure those are the folks who compose the commercial division bench. And, you know, to have the chance to serve as a law clerk alongside those jurists is, as Robbie has said, as Kathleen said, and others, just the chance of a lifetime. It's the kind of thing you couldn't better set yourself up for a career practicing in this space, you know, whether your cases are in the commercial division, in Delaware Court of Chancery, or, you know, in the federal courts. This is the prime training ground for all of that work.
To try and keep us to stay on time, I'm just going to ask Robbie and Kevin one more question each, just for a brief answer. But Robbie, what about innovation and self-improvement in the commercial division? You know, is that something that the commercial division is known for?
Well, Bob, I feel hardly qualified to answer that question when you are the person who has driven all that innovation and progress over the last many years. So the answer is
that's an overly
absolutely.
Generous comment, but I'm not going to fight with you about it. Go ahead.
Nor should you. I mean, the answer is absolutely. In addition to all the other important qualities and advantages that we talked about, I think it's fair to say that under your leadership, Bob, the commercial division has really been at the forefront of innovations in procedure, in incorporating technology, and encouraging resolutions and getting settlements, maybe when the issues don't need to be litigated. Again, it's hard. I have to say this again, as much as I love the federal courts, I think you're ahead of the federal courts in that respect. And it's another reason why I think it's such an attractive place for lawyers to bring and defend cases.
Kevin, let's finish up this segment. Any quick thoughts about discovery in the commercial division? Could you touch on that topic, please?
Sure, and I want to echo Robbie's comment of you know, feeling barely positioned to address this. I think last year Kathleen hit the nail on the head and said Bob is to the commercial division as James Madison.
All right, I'm going to interrupt you, Kevin. Go ahead, answer my question. Don't.
So the answer is, here are some of the reforms that a number of us alongside Bob have brought to the commercial division, among other things in discovery. Earlier, uniform procedure for robust and timely expert disclosure, limits on privilege logs, standardized forms and procedures that can be used, among other things, in the context of discovery, adjusting the burdens and creating opportunities in e-discovery. All of these are ways, among others Robbie referenced, where New York's commercial division has been an innovator, a real trailblazer in leading the way for business courts, technology-based and otherwise. Discovery, you will find quickly when you're practicing, can be a true slog and burden, but it can also be a critical opportunity to success in litigation. And having a court that does it the right way is the first step toward that success.
Again, in the interest of time, thank you both very much. I wanted to ask you some more about trials in the commercial division, but our next segment is two commercial division judges who are great experts on trials, and I think I'm going to move to them for that topic and some others. Our next topic is a little bit more on the history and the capabilities of the commercial division, and the two commentators on that are Justice Andrea Maisley and Justice Timothy Driscoll, both commercial division judges. And Judge Maisley, if I could start out with you and ask you for a compressed answer to a very broad question, which is, tell us a little bit about the history of the commercial division and where we are now.
Sure. Thanks, Bob, and thanks everyone for being here. Well, you know, Robbie and Kevin really covered it. Judge Kay and Bob Haig, we're grateful to them for starting the commercial division. It actually started in 1993 with 4 judges on a experimental basis in New York County, 2 women and 2 men in 1993. And though, in fact, New York has been hearing complex contract cases even further back. Of course, we've had contract cases forever, but since 1984, the legislature changed our general obligations law and invited cases with damages over $1 million arising from contracts anywhere in the world, with form selection clauses designating New York. So we see a lot of those cases to this day. Currently, we are 8 judges in New York County. We were 9 statewide. We are 27 judges. The experiences of the judges range from 2 former litigation partners who you're about to hear from Davis Polk and Simpson Thatcher, Judge Cohen and Judge Ostrager. Judge Ostrager, I might add, wrote the book on insurance law. We have former transactional lawyers, Judge Emerson, who was a banking partner at Sherman and Sterling, and Judge Borak here in New York County, who did structured finance, real estate financing, and private equity before he was a judge. We have former litigators from Bryan Cave, Skadden, Hughes Hubbard, and Kelly Dry. We have 1 former AUSA who did white collar cases, Tim. And we have 2 former CPAs. Speaking for myself, I worked on Wall Street for a grain trading firm before I got an MBA and went to law school. So that's clearly we have a wide range of experience. The types of cases that we're hearing, as I said, breach of contract, fiduciary duty, fraud, business torts. I'm trying to speed up because we're a little behind time. Unfair competition, Securities Act 1933, UCC cases, trade secrets, employment agreements, real estate transactions, commercial class actions, malpractice of accountants and lawyers, lots of internal affairs of business organizations, and this is just to name a few of the things that keep us busy.
Thank you, Judge Maisley. Judge Driscoll, we've heard practitioners' perspective of the commercial division. From your perspective, what makes the commercial division different from the other parts in the New York State court system?
Thank you for that question, Bob. And I'm very grateful for the praise of all the former panelists for the work of the commercial division judges. I share the praise and I give the praise to the lawyers who bring the great cases to me. And I think it really starts with that is we have judges who really want to be in the commercial division and seek to be in the commercial division. As a reward for that, we get what I think are the most difficult cases in the New York State court system. But as somewhat of a reward for that, we do have smaller caseloads than most of our brothers and sisters. Our brothers and sisters might have caseloads in the 600, 700, 800s. I'll leave Judge Graves, who's an administrator, to comment on that a little further in her segment. Our caseload is more like in the 200 to 300. So we do have the ability to really dive into our cases in a lot more detail, and that is expected. We expect it of ourselves, but the bar expects it of it also. Expected of us also. Because we have fewer cases, we've got more time to get involved with the cases. That includes at any conference, but also we are very, very much actively involved in settlement of our cases at different points along the process. The other thing, critical thing I think to emphasize that makes the commercial division different, and it was emphasized by, I still call her Professor Sullivan. She was my constitutional law professor 30 years ago, when Professor Sullivan spoke about the procedural rules in the commercial division. The commercial division has its own unique rules, which we as judges are, I would dare say, sticklers for, and we demand that the lawyers are sticklers for. And tying into what the commercial division law clerk might get out of that, the ability to understand what's in those commercial division rules will serve you well, not just in your clerkship with us, but will serve you for the years to come that you were in the commercial division bar. I clerked on the Second Circuit, like Professor Sullivan. I clerked for Judge Joseph McLaughlin 30 years ago. I still know the Second Circuit rules. Now, that only makes me popular at parties. I don't really need to use it anymore, but good to know those rules and good to have them and know them like the back of your hand forever. So I would say judges who want to be there, smaller caseloads, support from court administrators about those smaller caseloads, and the specialized rules of the commercial division, which judges very much do follow.
Let me ask the same question of both of you, both Judge Maisley and Judge Driscoll. Could you give us a couple of examples of the kind of things that your law clerks do for you? Judge Maisley?
Sure, thanks. So while I'm on the bench, either on trial or hearing motions all day, my law clerks are fielding questions from the lawyers. They are conferencing cases with the fabulous lawyers who come before us all the time. They are drafting decisions, or they are proofing the decisions I've written. They are, tidying up my drafts. They are supervising interns. I have a lot of law student interns, and let me give a little plug. Please send me your interns. We love having them here in my part. And so my law clerks are supervising those interns, meeting with them, reviewing drafts. And finally, my law clerks are reviewing the orders to show cause when they come in, and they are interrupting me during trial or hearing a motion if there's an emergency and I need to switch gears to a different case for an emergency. Finally, I meet with my law clerks every day at 4:30. We have a staff meeting and we go over everything that happened today, and we prep for tomorrow. Are they going to have conferences? Who's the conference with? What are the issues? What do we need to accomplish from our perspective in that conference? So that's my day.
Judge Driscoll, any other comments?
Judge McLaughlin told me on my first day as a law clerk in 1991, Timmy, your job is to make me look good. So I think all the things that Judge Maisley said tie into that theory. I would add one more thing that my law clerks do, which I think Judge Maisley hinted at, and that is I like to be a hot bench on every time I am on the record. And I have oral argument on every motion, and indeed on 70 to 75% of my motions, I'm deciding them from the bench. My law clerks are essential in that process, reading the motions for me, trying to find some seams in the logic, and offering some suggested questions that I might want to ask at oral argument, and perhaps even sketching out the beginnings of a draft decision if I am going to indeed decide that motion from the bench. My law clerks also take the first cut at any written decision that I'm making. That said, every word on anything I sign is my own, even if my law clerks are starting the process, but they are essential in the start of that process.
Judge Maisley, what are you looking for in a law clerk?
Well, excellent writer, excellent communicator. And to follow up on what Tim was just saying, not timid. I want someone who's willing to discuss and argue with me about the motions. It's also nice to find someone who's a lover of the law and procedure in particular, and language. You'll be hearing from one of my former law clerks who has just those qualities. Someone with a good work ethic. And by that, I mean the ability to not just do the job, but juggle multiple projects and emergencies coming in at them. And, being able to juggle all that and also have a life, because, you could be here, and some of us are sometimes here 7 days a week, working a lot. And so the clerks, you know, they need to have a balanced life. And I'm not really a good example of that. So, Tim?
Judge Driscoll, let me finish up with you with one last question. What's the future for the commercial division? I'm afraid you get 60 seconds to answer that, so.
Well, the future is innovation, innovation, innovation. If you had asked me 10 years ago or 20 years ago, Judge, what's iPhone? I would have said that's bad syntax, right? And now everything in our courts has to do with electronic discovery and whether messages are on an iPhone. If you had asked me perhaps 2 years ago, what's AI? I would have said those are the first and ninth letters of the alphabet arranged consecutively, right? And that is the future of the commercial division. So the future of the commercial division is Heraclitus's river. There is no constant except change. And we are embracing whatever is new and is thrown at us. And I just want to highlight, we have a potential rule change on the horizon, stressing that the commercial division will handle cases involving technology, assuming the jurisdictional threshold is met. So what is the future? If you're a young lawyer, the future is in the commercial division is whatever you're reading about now. That's what we're going to be doing. We're always going to be on the cutting edge of any business-related legal issue.
Thank you very much. I'd like to move on to the next segment of the program, and it's about, I guess the title of this is Making the Case for the Commercial Division, Hiring the Best and the Brightest, and Why Law Schools Should Encourage Students to Apply. And we've got 3 commercial division judges who are going to participate in that. Judge Barry Ostriger, Judge Marguerite Grays, and Judge Joel Cohn. I think somebody mentioned before, but Judge Ostriger was the longtime chair of the litigation department at Simpson, Thacher, and Bartlett. Judge Cohen was a senior litigation partner at Davis Polk and Wardwell, and Judge Grays is currently the administrative judge for essentially Queens, a very important and busy component of the New York State courts. So, Judge Ostriger, are you going to start on this? Or?
Yes, I'm delighted to pick this off.
We're just seeing the top of your head, though, Judge Ostriger.
All right, better?
That's much better, yes.
All right. Well, as you indicated, I've been on both sides of the bench during my career, and I actually had a federal judicial clerkship before I started a 40-plus year career at Simpson Thacher, which included being the chair of the litigation department for 12 years. I tried scores of cases to verdict and argued dozens and dozens of cases in appellate courts, including several cases in the United States Supreme Court. I must say that I'm most grateful to have had the opportunity to be a commercial division justice, and I want to thank all of those who spoke in praise of the commercial division before our turn came. What I wanted to emphasize in the limited time that I have is what a rare and special opportunity it is to be a clerk in the commercial division. As Justice Maisley intimated, we're a very busy court and we have to be very efficient. We're conducting multiple bench and jury trials a month. We're receiving and deciding literally dozens of motions every month. We're conferencing cases all the time, and a young lawyer who gets the opportunity to work side by side with a commercial division judge will start his or her career at a business law firm light years ahead of an associate who joins a law firm directly out of law school. I can't emphasize that point enough because I've seen it firsthand during my career as a practicing lawyer. When you graduate law school, you have analytic skills and some substantive knowledge, but you have very little insight into how the courts work and how to get things filed in the court and what the rules of the court are. And if you clerk in the commercial division, by virtue of the nature of the work of the commercial division, you learn New York procedure, which is not taught at most law school. You learn what the CPLR is. You learn different mechanisms for filing motions and filing orders to show cause. You see some of the best lawyers in the country, including the best lawyers in New York, submitting motion papers and arguing complex motions. You learn an awful lot. And, you know, I'm proud to say that the last 3 law clerks that I've had, each of whom served with me for 2 years, are now either at Paul Weiss or at Davis Polk. I'm not sure any of them would have received offers from those firms straight out of law school, but they're valued and appreciated. One of them was put on a trial 3 days after she left employ in my chambers, and drew rave reviews from one of the senior partners at Davis Polk for her ability to assist the Davis Polk team in navigating their way through the pretrial and trial process of the case in the commercial division. And so anyone who's listening, who's counseling a law graduate to be, the best advice that you can give them is to attempt to secure a position as a clerk in the commercial division, because it will, as the other panelists have indicated, be the foundation for being able to progress as a lawyer. And that's what I would want everybody to have as takeaway from my brief commentary.
I'm not sure, is it Judge Cohen or Judge Grace? Who's going to go next?
Happy, Margaret, if you want to go next, I'll go last.
Sure. My remarks are brief. I understand the need as an administrative judge to keep it moving. I've been thank you very much for this opportunity. I've been in the commercial division since 2005, and I'm now currently the administrative judge for Queens Supreme Court civil term. I just have a few points to make why it's so important to encourage law students and recent grads to seek clerkships. Experience, networking, specialization. Those are key. The experience that you're going to gain in the commercial division is unrivaled. It offers a unique opportunity for all students and alumni to immerse themselves in intricate legal matters. You get that hands-on experience that you really can't get elsewhere. And the rigor of the work prepares you for your next venture in life, hopefully in a firm that does commercial litigation. The network is exceptional. As you can see here from the participants in this panel, the connections that students and alumni make are also invaluable. You meet a number of people in various areas of life, not only across New York, across the United States, internationally as well. So it's a very great network to become a part of. Specialization. You learn to hone your craft. Once you become a clerk, you get the opportunity to learn things you would ordinarily not get the opportunity to do. You get to specialize in understanding different aspects of business law. As it was indicated earlier, we're on the cutting edge of technology, generally in the commercial division. And those tools will always help you wherever you decide to go. But of course, we hope that you continue doing commercial litigation. Finally, I have to always make my pitch for diversity, coming from the County of Queens, which is the most diverse county probably within the nation. We're always looking for diverse students from diverse backgrounds to join our roles in the commercial division and to pick up and learn all the valuable, specialized, complex information that we have to share. So that's my pitch. I hope you'll join us, whether you're in New York County, Queens County, Kings County, or any county where the 27 judges sit. Thank you.
Judge Cohen.
It's very difficult to add anything to all the great points that have been made. I'll be quick. I will say when I started here, I genuinely was surprised by the breadth of the cases that we dealt with and the complexity and the quality of the lawyers and my colleagues. I had high expectations and they were exceeded immediately. I think that this clerkship, I clerked in a federal court, which I thought was a great experience. I genuinely, having worked in a law firm for a long time and now having done this and been a clerk, I really can't think of a clerkship. I know this sounds self-serving, but I do believe it. If I had a younger sibling, I would tell them the same thing if I were giving advice. If you're interested in a career in commercial litigation, I literally cannot think of a job that would set you up better. And the only thing I'll add, since all the other comments have been made, I had dinner last night with a former clerk who was at a similarly high-ranked firm, and he was kind of going through, which I'm sure will echo in what the next panel is going to talk about, just the many, many ways in which the intensive experience of working very closely with the judge on high-end issues and getting extremely substantive experience, that he really hit the ground running in ways that seemed shocking to me, how quickly he was moving up the ranks in terms of experience and opportunities. So it's real, and I think that all the people who made the point that this is a partially undiscovered gem of an opportunity for law schools to really be thinking about for their students, I wholeheartedly agree with.
Thank you very much, Judge. Our last segment of the program is on a specific clerkship experience. And we've got two panelists, both of whom were former commercial division law clerks. Kevin Quartino from Foley Lardner and Morgan Manley from Smith, Gambrill, and Russell. And Kevin, let me start with you. What hard skills did you learn from working in the commercial division?
Oh, well, first of all,
I'm contrasting now because I want to ask Morgan a question about soft skills. So I want to start with you on hard skills. So if you could limit your answer to that.
Understood. Well, first of all, thank you, Bob, for having me here. When I think about hard skills, the first thing that comes to my mind is becoming an expert in New York's commercial law and New York's procedural law, which is what's going to make you particularly valuable to a major law firm, as Justice Collin has just noted. And, the way that skill set is developed is by working in close quarters with a commercial division judge who is, in no uncertain terms, an expert themselves. And you're going to pick up so much just from working with them. And I think Justice Maisley alluded to it earlier, but Justice Maisley was my teacher. And I think about things she said to this day when I'm working. If you're looking at a contract, you should always be thinking about ambiguity. It's things like that. It's also having an opportunity to read day in and day out briefs written by the best lawyers at the best law firms in the country. When those are the briefs you read all the time, you're not only learning esoteric commercial concepts from lawyers like Professor Sullivan, Roberta Kaplan, Tracy Davis, but you're also just seeing what good writing looks like and how all these different firms put forward a really good brief. And then you can say to yourself, well, I like this was persuasive, this is a style I want to use, this is a style I'm going to use. And in terms of another hard skill, I just want to flag, because I know Justice Maisley discussed it briefly, the conferencing. If you're the only person in the room seated across the table from partners at major law firms, you learn quickly what's persuasive and what's not. And you also learn, I would say, how to listen for things, which is so important in private practice when you're taking depositions and things like that. And one thing I just want to flag, because Justice Maisley noted it, I 100% feel comfortable grilling a witness or another attorney, because I watched Justice Maisley do it. I watched her grilled Skadden partners, every partner you could imagine, and that's invaluable.
Morgan, Kevin's just been talking about the hard skills. What about the soft skills? What can you learn there in the commercial division?
Yeah, so, the first thing, and I'll pick up where Kevin left off, is with respect to the conferencing, you have to be creative. You are the person often trying to resolve a discovery dispute. Of course, the judge will give input at times, but you are the person really who's trying to figure out a solution without resulting in motion practice. And then there's also being creative with respect to problem solving. I can't tell you how many times I met with either Kevin or other of Justice Maisley's law clerks, Justice Ostrager's law clerks, Justice Cohen's law clerks. All of us got to know each other, not just on a personal level, but also we shared thoughts about how, cases they were handling or issues that we were dealing with that they were also dealing with. I remember at the time how to deal with recent First Department sealing cases that had come down, or a big issue. Adaptability is another one. Being able, Justice Maisley alluded to that, but being able to adapt between multiple cases. As a commercial division law clerk, you're responsible for really knowing the history of a case from start to finish. Even if you start, you have the notes of the prior law clerk. And so you are responsible for maintaining those notes and then informing the court about what has happened. And I can't tell you how much practitioners appreciate a law clerk who really keeps good notes. But then afterwards, having that skill, and I'm, jumping ahead, but having those skills, take those with you of really good note taking. So that way your partners can rely on you as well.
Kevin, what about exit opportunities for commercial division clerks? What are your thoughts on that?
Well, Bob, I think the exit opportunities are excellent. Commercial division law clerks go to major law firms, mid-sized law firms, boutique law firms, the big law firms that you can think of, Skadden Arps, where Justice Cohen's law clerk went. You heard just where Justice Ostrager's law clerks went. I'm at Foley and Lardner, but you name it, they're there. I know Professor Sullivan, she hired a former commercial division law clerk who worked for Justice Branston. And so if you want to go into private practice, this is the job to take early in your career. But law clerks also go on to other courts. So they go work at the appellate division. There's a current law clerk in the New York Court of Appeals who worked at the commercial division. So the opportunities are I'd say pretty endless. And I think what's important just to flag, I know we've got deans on the call, we've got students on the call, and if you want your law students to get that technical, complex commercial litigation foundation, that's not only going to help them make hundreds of thousands of dollars, but give them the capacity and the skill set to make millions of dollars in 20 years, 30 years, this is the court that they got to go to.
And Morgan, last question. How do the law firms benefit from hiring commercial division clerks?
Well, first and foremost, understanding how the court works is an invaluable tool and knowledge base. I believe Tracy referred to that earlier. Just understanding where in the court is my ex parte motion right now, or where is my order to show cause at this moment, and being able to walk not only partners but also a client through that, and again being able to talk to the right clerk in the commercial support office or the part clerk, and understanding the different roles, understanding how invaluable it is to read not only the commercial division rules, but the part rules. I can't tell you how many seasoned attorneys don't understand that. And so Justice Maisley's rules were always notorious for being amended with great frequency as needed. And so being up to date on the court rules are so important, and understanding that. In terms of the minute I got here, I was put on a trial at Smith Gambrell, and it was actually a federal court trial. And I can't tell you how many skills translated over to just knowing what I needed to do to prepare, having done a jury trial with Justice Friedman, being devil's advocate for your partners, because anyone who practiced before Justice Friedman, for whom I clerked, she was notorious for pulling the metaphorical books off the shelf and really trying to get to the answer of what is the law in this issue. And so being able to harmonize law and have that presented to your partners. New York law is notoriously hard to research because of we don't have an impaneled system. And so being able to understand that from the get-go. And finally, the day I got to my job 4 years ago, the first thing I was handed was to review a senior partner's proposed order to the court, because that is what I did all day. And I made a lot of red lines. And so just being the oversight, knowing all these things and being the go-to person is really invaluable to law firms.
Thank you, Morgan. Just a couple of last comments, and then we do have some questions that have come in, and I think in particular, the judges on the panel can help us with this, because many of the questions relate to exactly how do you find out about these clerkships? Where do you look, and how does a student, locate them, and how do you apply, and so on and so forth. But just the last comments, just to sum up, in a couple of sentences, I think the thrust of this program has been that a commercial division clerkship is going to make your students better lawyers. They're going to get better jobs as a result of their experience, and they're going to do well in those jobs as a result of the experience that they've had, and that they're going to be grateful to you as members of the faculty and staff of your law schools for what you've done for them, and that's entirely appropriate. And I think we've covered that very well. Judge Maisley or any of the other judges, does anybody want to talk about the process and how you find out? How do students find out about internships and clerkships?
I'll jump in first. So you go to our web pages. Each and every one of us has a web page, and it has instructions on how to contact us. And it has, if we have an opening, it will be on our web page. But even if we don't have an opening, if someone's interested in clerking for me, they should just send me a resume, because openings happen unexpectedly, unfortunately, for a whole host of reasons. So, I will post a position as soon as I know about it, but it doesn't hurt to just send a resume to a judge. And I think Joel can talk about this. And as a matter of fact, I haven't posted it yet, but I will be posting a position for September 2024. So send your resume, tell your students to send their resumes to me now. It doesn't need to be posted, but it will be posted on my webpage. It will be posted on the court's general page of open positions. And I will send it to every bar association I know, and law school deans that I know, and friends and former law clerks to help me find the right person.
Judge Cohen?
Yeah, I think that's exactly right. And Andrea may be referring to that this summer after one of these kinds of sessions, I got an email from a law student who was a summer associate asking about clerking because we had been talking about it. And as it happened, I ended up hiring her a week later for the following year. We do try to hire. Somebody asked about whether it's an annual thing. In an ideal world, it would be a regular process, like Judge Mensley said, but it is a little episodic. Our postings are available on, again, the court website. I'll just, echo the most important thing is we all have email addresses to our, for our parts or to ourselves. We keep all of those things, and as positions arise, we will let you know. So, but largely, at least for me, every September is when I try to have a new group coming in.
Another question was raised in the questions that were submitted about clerkship bonuses. And I don't think that's really a question for the judges, although they may know something about it. But I'm not sure that there's any uniformity among the firms at all.
Bob, I'd be happy to address that. For our firm, Quinn Emanuel Urquhart Sullivan, we do pay the clerkship bonus to incoming associates who have clerked on the commercial division. We do it, bonuses always have to be approved on a case-by-case basis, but we have regularly approved those in past cases, and we'll continue to do so in the future, because we regard a clerkship on the commercial division as providing an extremely valuable experience and potential asset to our firm for all the reasons the panelists have explained so beautifully today. So, and we also give full class credit. That was another question. I can't speak for all law firms, but I think we're fairly typical of the market. And so I think that should give great assurance to the people who clerk on the commercial division.
I would add to that, that I know from speaking to each of my last 3 law clerks that they not only receive clerkship bonuses, but they receive the same salary as people in their class. So they got full credit for the 2 years that they clerked on the commercial division.
I'm just looking at the questions, and they mainly apply to the application process and where you find out about the opportunities. And I think we've covered that. If anybody, we've gone over by a few minutes. Once again, if there are any questions from members of the audience, you're welcome to send me an email. We'll try and respond to it and get you an answer. And thank you very much to all the panelists for providing a very good overview of the subject matter. And thank you to the audience for joining us today. Take care.
Thank you.
Thank you.